Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We are especially honored and pleased to be here at the West Virginia University College of Law. I want to thank Dean Brewer and her staff for allowing this event to happen here. We're grateful for your warm hospitality and appreciate the turnout this morning. We probably should have sold tickets, I guess, at a premium. And so we're ready to hear argument in 3 cases this morning. First up, 24-2262, Wolf Run Mining Company versus DOWCP. Mr. Mattingly. Whenever you're ready, sir.
May it please the court. I am William Mattingly. I'm here on behalf of Wolf Run. It's appropriate that the court got relocated to Morgantown to hear this case because we're literally looking down at the NIOSH facility where the medical articles and the criteria document that form the basis of the defense of this case were actually written. So it's happenstance that we're in Morgantown where those documents were. First, let me tell you a couple ground rules that I appreciate that I'm going to follow in the argument. I'm not going to ask you to reweigh the evidence. I'm not going to argue that the preamble can't be used as a scientific primer. I'm not going to argue that the administrative law judge is the one who needs to resolve the battle of the experts. I am going to argue that the administrative law judge did not resolve the battle of the experts. And the first expert that was not resolved was Dr. Jarbo.
You say they didn't resolve the battle of the experts?
That's correct. They did not. She did not. Judge,
you say that rather than that she erred in resolving it.
She did not address the pinnacle issue, which Dr. Jarbo explained in detail in his report. To get to that.
The presumption applies here, doesn't it?
Absolutely. There is a presumption that he is totally disabled.
I'm glad to hear you say that because you wouldn't know it from reading your briefs.
I conceded that the presumption was invoked because he was totally disabled.
Okay.
That's not an issue in this case.
That's the 15-year presumption.
It is.
For working underground in the coal mines here of West Virginia, basically.
Correct. And having a totally disabling pulmonary disease.
For multiple coal companies.
Correct.
Multiple jobs.
Multiple jobs. And in addition to that exposure,
he did not everything in the coal mines.
He did a continuing cigarette smoke.
He said 32 years, I think, or 34 years. And the ALJ or the IJ gave him 27 credit for working underground.
Correct.
He was the fireballs.
And one of the other observations that should be made in this case, he didn't have clinical pneumoconiosis. He didn't have X-ray evidence. So the question is, what was causing his disabling obstructive lung disease?
The question is, how did your client rebut the presumption?
With both the opinions of Drs. Jarbo and Dr. Renavagna. Dr. Jarbo explained using the medical literature in the preamble why a parallel reduction in certain parameters of the pulmonary function testing allowed him to conclude this was an impairment related to smoking, not coal dust exposure.
But that's not rebutting the presumption because the two things are additive.
It does rebut the presumption because he is able to say that the two exposures were not additive in this case. And the additive language comes out of the preamble. And that's not a rule of law that the Department of Labor invoked in the preamble. The preamble is pretty specific. When they talk about the new definition of pneumoconiosis, they want to explain that COPD does not have to be shown to be potentially caused by exposure to coal mine dust. That was the purpose of all the articles that they cited. This case involves the pulmonary function study, put nose clips on your nose, you blow out into a tube. They measure certain parameters, the amount of air you can get out in the first second, the total amount of air you can get out, the ratio of those two.
Can
It
I,
determines.
Mr. Manley, sorry to interrupt you, but where did the ALJ fall short in not resolving the battle of the experts? Because as I understand it, the ALJ gave at least three reasons why she discredited your client's experts. The first being that this coal miner's impairment wasn't totally responsive to bronchodilators, which suggested that it wasn't just the smoking that was causing his disease, but his exposure to coal mine dust. So that's the first thing. Second, she said that the coal miner's pulmonary function showed that his FEV subscript 1 score declined more than the FVC score. And you probably know a lot more about that than I could ever hope to know. But she said that the preamble says that this can be caused by coal mine exposure. So that's the second thing. So let me just stop there and give you those two reasons. Why isn't that enough for this record?
Let me address the second one first.
All right.
And that is the crux of this case, because the preamble does talk about the ratio of the FEV1 to FVC. It does so very specifically between 79, 940 and 943 in defining COPD. It's a parameter of COPD. That ratio tells you whether you have an obstructive disease, can't get air out, or a restricted disease, have problem getting air into your lungs. Dr. Jarbo explained the medical articles that the Department of Labor had in the preamble that discussed on those same pages, explained that that ratio is preserved. Although there's obstruction from coal dust exposure, that ratio is preserved and goes down in a parallel manner for both of those parameters, the FEV1 and the FVC. Whereas in smoking, the FVC is preserved, but the FEV1 drops significantly. And why I'm here.
The medical literature that Dr. Jarbo relied upon, wasn't that prior to the preamble, prior to 2000?
It is both. He relied on some articles after, but he relied on the very articles that are discussed in the preamble. And he discussed the 1995 criteria document that the Department of Labor acknowledges in its discussion of legal pneumoconiosis that they're relying on. And he explained that that document, which I offered as Employers Exhibit 4 in this case, specifically says coal dust does not affect the ratio, smoking does. And in this case, it matters because that ratio was dropped incredibly low, but that wasn't the only parameter. Also, the FVC was preserved when you did lung volumes. Lung volumes are done by a different method. You sit in a body plethysmograph, which looks like an old telephone booth, and you just breathe in and out. It tells you how much air you get in your lungs and how much is trapped. It was incredibly trapped, hence more consistent with smoking than coal dust, because coal dust doesn't cause that. Judge Dom never dealt with that issue. She said he relied on the ratio. The ratio in case law has been said not to be a valid way to distinguish. But the case law and the doctors that relied on cases previously didn't have that criteria document in the record.
Were those all presumption cases or not?
Many of them were. Many were presumption cases, but I don't know that it matters who has the burden of proof in this case, because clearly my client does. What matters is the administrative law judge didn't address the scientific controversy. And that controversy was used to say, we want to refer to the preamble in recent decisions of the court, American Energy and Extra Energy, to resolve the battle of the experts. That hadn't been done in this case because this record's unrebutted. No one says
So
that
you're not saying that the ALJ could not have relied on the preamble, just that the ALJ didn't do it right in this case?
Correct. The ALJ ignored what we presented.
But that, I mean,
We
it
relied
looked
on
like the ALJ did address the things that you just presented, including the reversibility rationale and your expert's view that smoking was more harmful than coal dust. And I'm looking specifically at JA 303 and 304 for that.
303 and 304 is the place to look. Let me grab. The problem is on 303, if you look at the paragraph, Judge Dom says, this is about halfway down, the preamble to the revised regulation states that a reduction in the FEV1 FVC ratio is a marker for obstructive lung disease, including that caused by coal mine employment. That's true. She didn't take it to the next step. Dr. Jarboe explained when that marker is incredibly increased, it helps to determine causation. And he used the medical articles that general statement came from and explained in his report in multiple paragraphs why the parallel reduction of those two parameters was not here due to coal dust exposure because it was so disproportionate and the lung volume supported that. Judge Diaz, you also asked about the
Before we
reversibility.
get to that, if the ALJ had simply rejected that out of hand in light of the presumption, that would have been wrong.
That's wrong according to the APA. And I think it's wrong according to this circuit's review of the cases, because you need to have the ALJ weigh the conflicting relevant evidence. And here the ALJ has never addressed Dr. Jarboe's explanation that ratio was so elevated and supported by medical literature that that's due to smoking. That's not due to coal dust exposure. You ask about reversibility. The ALJ has stood the argument on its head. Dr. Jarboe and Dr. Renavagna did not argue that complete reversibility shows that this is not due to coal dust exposure. They argued some reversibility has to be considered, and then you question what's causing that reversibility. Dr. Renavagna thought it was asthma influenced by smoking. Dr. Jarboe thought it was smoking. There doesn't have to be complete reversibility to diagnose asthma. And Judge Thacker, you asked about where Judge Dom was wrong. 304, Judge Dom says Dr. Renavagna did not address the fact that the results did not return to normal after the administration of bronchodilators. In his report, as I put in the brief, he addressed in detail and even said some ALJs in adjudicating these cases want to see complete reversibility. That doesn't happen. You have remodeling of the airways, you have repeated inflammation from smoking, and that's what causes the residual lack of reversibility.
But isn't it, as I understand the law in this area with respect to legopneumoconiosis, one can have a condition like asthma, which standing alone might not suggest disease impairment as a result of coal dust exposure, but could be aggravated by coal dust exposure. So the two aren't mutually exclusive. So it seems to me that that's what the ALJ was suggesting in this case.
But the ALJ never got there with that type of language. And we can't fill in the blanks for the ALJ, which was my complaint with what the Benefits Review Board did in this case. They added case law and tried to explain why the ALJ's decision was supported by substantial evidence and correct. The other two doctors in this case were not even talked about by the Benefits Review Board, and that's a problem. Dr. Green's opinion cannot be credited because in his report, he says there's legal pneumoconiosis based on a 34-year occupational exposure to coal dust. It's the only reason he gives. Joint Appendix 168. In his deposition, he admits you can't diagnose legal pneumoconiosis knowing length to coal mine employment. That employment alone doesn't substantiate the diagnosis. You have to have something else. And in this case, when presented with a disabled miner who's a smoker, he always concludes it's due to both. The preamble's pretty clear. And this circuit's case law is pretty clear in American Energy. That is error. You can't just as a physician presume based on years of exposure that there's clinical pneumoconiosis. It admixes the legal presumption with the medical causation that a physician has to do. Those are separate. A physician can't rely on the 15-year presumption in a black lung case to say that exposure had to cause the obstructive lung disease in this case.
But, the presumption has to be doing some work here. You would concede that, right? It has to inure to the benefit of the minor. And it seems, almost intuitive that if someone spends 20 plus years in the coal mines and is also a smoker, that it just seemed logical that those two would be additive. I mean, I'm not a doctor, and I guess your point is that it's not always the case.
And one of the strengths of my defense in this case was Dr. Warchowski's deposition. He was the Department of Labor doctor. He said this is legal pneumoconiosis and smoking. I showed him the 2011 pulmonary function study that was close to normal. And he said, aha, that changes my opinion. The impairment here is more due to smoking. So the Benefits Review Board was wrong, as well as the ALJ, in not looking at that concession by Dr. Warchowski, who explained
But
chronology
due to
matters.
smoking is not enough to rebut the presumption, is it?
It is not, but Dr. Warchowski's opinion supports the analysis from Dr. Ranavanya and Dr. Jarabo, so it changes the mix. So you've got 4 doctors here. Dr. Green can't be credited at all.
Go on each side, basically.
Correct. Well, now, Judge King, I'll
That's-
debate that because I think Dr. Warchowski's on my side.
Did you file a reply brief that said all this?
I didn't.
Why would you abandon your opportunity to file a reply brief in a case like this?
Because I felt strong enough that the administrative law judge's decision was not well explained, as I explained in the opening brief, that she just failed to do what she had to do. She didn't resolve the battle with the experts and explain why Dr. Jarabo's explanation that that ratio was so disproportionately increased that allowed him to distinguish along with the other clinical factors. I've saved the rest of my time for rebuttal.
All right, thank you, Mr. Mattingly. Mr. Austin?
Good morning, Chief Judge Diaz, Judges King and Thacker. It's an honor to be here today. This is my first time at West Virginia Law School. It's a beautiful campus, and I'm honored to be here. May it please the court. My name is Brad Austin. I represent the coal miner in this case, Mr. Harold Baisden. Mr. Mattingly gave a lot of information there a moment ago about FEV1 values and FVC values and doctors' medical reports. But Judge Diaz, this case, as you said, is a 15-year presumption case. And it was not enough for the employer to explain that cigarette smoking caused chronic obstructive pulmonary disease in this case. The employer's burden is to rebut that there is also a contribution from coal mine dust exposure. And that's the crux of what's going on in this.
And I think if I understood his argument correctly, he was now accepting that burden, but arguing that his experts somehow met it, but that the ALJ didn't fully consider all of the expert opinions in that regard. What's your response to that?
I agree, Judge Thacker. I think that's the point that he is trying to make. But the problem, Judge, is, these doctors may have made a sound medical argument as to why they personally believe that cigarette smoking was the entire cause of this man's pulmonary impairment. But the problem is their job is to convince the fact finder. And the fact finder in this case, Judge Dom, was not convinced by that. And it's not this court's role to go in after the fact and reweigh the evidence when substantial evidence.
What if the ALJ didn't fully consider the evidence as petitioner is suggesting happened here?
Well, I certainly don't concede that that's not what happened here, but I would make this argument if in the hypothetical situation, maybe she did not. There's multiple reasons, Judge Thacker, and a judge doesn't need a laundry list of reasons to, discredit an expert. The judge is not bound to accept the opinion of any physician in any black lung case. That's the role of the fact finder. And when you look at the opinions of Doctors Jarbo and Ranavaya, this judge did not provide one reason. This court has had.
You're saying this judge didn't provide us just a single reason why she was rejecting those experts. She provided a multitude of reasons.
Exactly, Judge Thacker. And I can provide you with some of those reasons if that helps. But I think Judge Diaz pretty much during the opening argument there kind of outlined exactly what I was going to say, because the judge did provide multiple reasons in this case. And this court has recently, over the last, I guess, year and a half, been presented with these cases where there's coal mine dust induced chronic obstructive pulmonary disease versus cigarette smoke induced chronic obstructive pulmonary disease. And this court has published 2 recent decisions in the American Energy versus Good case and in the Extra Energy versus Lawson cases. The problem with both of those cases when you go to apply them to this case is that neither of those cases were 15-year presumption cases. But we do have a lot of guidance from this court on what it's looking for when it reviews an administrative law judge's findings. In the Good case, the American Energy case, the administrative law judge did cite the preamble. The American Energy case stated that that was perfectly fine to do. But the problem with the administrative law judge in that case was that no other explanation was provided other than a bald declaration of employers' experts who only opine that cigarette smoke induced COPD is present, and only a bald declaration that the preamble supports the claimant's experts who provided that both coal mine dust exposure and cigarette smoke induced COPD was the cause. So the American Energy.
Sorry to interrupt you, but
Go ahead.
I think Mr. Mattingly's point and perhaps his frustration with this, the way these cases seem to work out is you've got what is intended to be a rebuttable presumption, but at least from his perspective becomes almost irrebuttable because of the nature of you've got 2 experts on one side, 2 experts on the other, both equally qualified, and the ALJ invariably sides with the expert for the minor in a rebuttable presumption case. Maybe that's not accurate. Maybe there are cases where that isn't the case, but has this in fact become an irrebuttable presumption?
No, Judge Diaz. I think that's a fair point that Mr. Mattingly makes, but I don't think it's an accurate one because there is a rebuttable presumption. Mr. Mattingly and I do a lot of these cases, Judge Diaz. I mean, we're down in the trenches handling hundreds of these a year. We're before this court quite often arguing them on appeal. There are cases where employers do rebut the 15-year presumption.
And how do they do that? What evidence do they need to bring forth to rebut the presumption that might otherwise seem irrebuttable?
Well, Judge Thacker, I mean, it's hard to give you a hypothetical of exactly what evidence could be brought forth to rebut.
Have you ever lost one of those cases where you had the rebuttable presumption?
I think I have, Judge Diaz. I've lost cases like that before. But I don't want to get too far out in the weeds. We're here today on this.
No, I understand. I guess the point is though that the ALJ still has some work to do, even if it's a rebuttable presumption, right?
Absolutely, Judge Diaz. And I think that's why the recent published decisions from that American Energy case and the Extra Energy case are important because American Energy said this is not enough for an administrative law judge to just simply quote the preamble and make bald findings. But in Extra Energy, the judge also cited the preamble, but fully explained her reasons for discrediting the experts. So when you consider those 2 cases in conjunction, this court has really outlined through those 2 recently published decisions what is needed for an ALJ when consulting the preamble. And that's at the crux of employers' argument in this case. This case is more akin to the Extra Energy case because in this case, like you said, Judge Diaz, there were multiple reasons why Dr. Jarbo's opinion was discredited. This parallel reduction in the FEV1 and the FVC with a preserved ratio. That's an argument that employers' experts frequently make. The problem with that argument, though, is in a coal miner who has an additive contribution from both coal mine dust exposure and cigarette smoking, that parallel reduction may not continue to exist. Because if both of those impairments are causing an impairment, then that pattern may not always be accurate. That's the problem when it comes to applying patterns of impairment to specific individuals.
Now, you just made the argument for why that opinion should have been rejected, but the question is, did the ALJ make that point?
Well, the ALJ was not convinced. That is the proper standard. The ALJ was not convinced
Don't they
by
have to
Dr.
explain
Jarboe
why they are not convinced?
because of the fact that coal mine dust exposure, as supported in the preamble, can cause a purely obstructive, restrictive, mixed obstructive, restrictive type of impairment. And the fact that you don't have this parallel reduction, or you do have a parallel reduction, does not automatically equate to cigarette smoking induced COPD. That's the reason that the ALJ cited. That's on page 303. There were other reasons. Partial reversibility, Judge Diaz, you talked about that as well. That does not account for the residual portion of the impairment. We don't have full reversibility. It's entirely reasonable that a portion of the impairment could be due to coal mine dust, the residual portion, and the reversible portion could be due to cigarette smoking. The ALJ did not credit Dr. Jarboe. She was not convinced by that. I also got a chance to ask Dr. Jarboe some deposition questions on cross-examination. The judge reviewed that deposition as well and was not convinced. And then finally, even if cigarettes are harmful, more harmful, as Dr. Jarboe stated repeatedly in the deposition, it doesn't mean that coal mine dust exposure is not also harmful. The additive contribution is key here. The judge was not convinced that Dr. Jarboe had fully explained that no part of the miner's impairment was caused by cigarette smoking. Now, perhaps another ALJ would have reviewed the exact same evidence and found for employer, but that's not what we're here for. This ALJ was the fact finder. This ALJ was tasked with resolving a battle of the experts.
You think
And
a different ALJ could have reviewed this very same evidence, found to the contrary, and you would have no argument before this court, given the presumption?
if a different ALJ would have reviewed this evidence and found to the contrary and fully explained her reasons, his or her reasons for crediting the opinions of Doctors Jarboe and Ranavaya, then it would be supported by substantial evidence, and this court's review would have to be a deferential one, just like I'm asking you to do in this case.
But if the principle is that smoking and exposure to coal mine dust can be additive with respect to an impairment, always, sometimes, maybe, well,
Can be is the key term, Your Honor.
okay.
But in this case, the burden of proof is key. And that's
On, you've
ex-
got this 15 years is on the coal company. Does it make any difference if he had 30 years underground?
well, Judge King, that's a question for a fact finder. I mean, I would assume that it
In
wouldn't.
a lot of these cases,
I would,
and you have clients that have 20, 30, 40 years, not 15 years.
Mhm.
When they have 15 years underground to get the presumption and have another 20 years above ground.
sure.
They weren't exposed as much. As if they had here, he had something like 27 or 30 or 32, 34. In dusty conditions.
Absolutely.
And I mean, the job titles for this fella are devastating for the coal company.
Well, Judge King, I think in this case, all of the experts acknowledge the fact that there's multiple risk factors. He did have a significant cigarette smoking history. He did have a significant exposure to coal mine dust. And that's really at the heart of this issue. Was it a combination of coal mine dust exposure and cigarette smoking that additively caused COPD? Was it only coal mining that caused COPD? Was it only cigarette smoking that cause COPD. And that is what the ALJs do in these cases. They are tasked with receiving evidence, considering qualifications of experts, understanding reports, and resolving that battle of the experts. And Judge King, what I was going to say before your question was the burden of proof is key in this case. You know, if the claimant had the burden of proof in this case, you know, we may have a different question before the court.
But here the burden of proof's on the company.
The employer had the burden of proof, and the employer has to establish not that cigarettes caused an impairment. The employer has to establish that coal mine dust did not also cause the impairment. And that's where the employer's evidence falls short in this case. Your Honors, do you have any additional questions?
We don't.
Judge Diaz, thank you for the court's time, and I would just ask this court to affirm the decision and order awarding benefits and the decision and order affirmed by the Benefits Review Board. Thank you.
Thank you very much. Mr. Mattingly.
I can be brief. Chronology matters.
That's always good.
That's- Chronology matters. Dr. Jarbo, Dr. Ranavanya looked at a series of studies over time and put that into perspective as to what was going on in this minor. Judge King, you're worried about the length of employment. The Department of Labor doesn't have a rule that if you work for 30 years, you get benefits. It'd make all of our lives easier. If they have that rule, they don't. So lots of minors can work lots of years and thankfully not develop pneumoconiosis. This man did not.
On what their jobs were.
It can. This man
yeah.
did not develop.
I've been around a lot of these cases too.
You have.
And some mines are dustier than others. Some types of coal are dustier than others. And been in there 15 years, this Congress decided that needed to go into the law. But some of these fellas are in there 30 years on the face.
So
And
the other
you
point,
know from your experience what the results of that are.
the other point that I need to make, Judge Dom didn't do her homework, didn't show her work, which was an expression that came out of Extra Energy that I liked. It took me back to math class where you had to show your work. I filed a brief with her. It's substantially like the brief I filed with this court. I pointed out the page of the criteria document that says smoking was associated with a reduction of the FEV1 FVC ratio, but dust exposure was not related to this ratio. That's what Dr. Jarbo explained. That's what all the articles he cites on page 34 of the joint appendix that came out of the preamble's discussion of legal pneumoconiosis say. It's different than saying that ratio can show obstruction and minors get obstruction. But when that ratio is changed in quantity, it may tell a physician what's causing the disease. That medical testimony is unrebutted in this record. That medical testimony has never been dealt with by the agency fact finder. That's what the agency fact finder needs to do. There are multiple reasons, but you take that reason out and say, well, those other reasons might have been enough to satisfy the fact finder. We can't make that presumption. It may be that once the fact finder reconsiders that first reason, those other reasons may fall to the wayside. That's the fact finder's job. They need to do their job. So I'm asking the court to vacate the award and remand it back for the ALJ to actually correlate Dr. Jarbo's opinion explaining, using the science in the preamble, why this man's ratio is consistent with smoking, not coal dust exposure.
So had she done that, you might have a different argument on the merits of the analysis, but that's a much harder argument for you, I think.
I don't know that I would be here if she had done that.
All right. I'm sure the folks here would miss you, but you have anything else?
I don't. Thank you.
Thank you. All right. I appreciate the court appreciates the argument by both counsel in this case, very able arguments. We'll come down and greet you and then move on to our second case.
See you, Judge. Judge King, good to see you. Glad to see you. Get a cup of coffee this morning.
Strongest argument is the first one in your brief and your least strong argument is the last one in your brief?
Not necessarily, Your Honor. I think they're all important. I would say probably the first two are quite critical, not to diminish the third, but
Right.
those are the two I thought Your Honors might be interested to hear about. I'm happy to
And the
start.
third is the hearsay issue.
That's correct, Your Honor. Not that I want to shortchange that one, but that's a
So you
little
had
more.
a trial here for the purposes of the students. You had a trial of your client,
Yes, Your Honor. That's right.
and he was convicted. You're saying there was bad hearsay evidence.
Yes, Your Honor.
Go ahead.
That issue is a little more straightforward, just as important, a little more straightforward. The first two, I think, are legally a little more complicated, so I'll start with those. I'm happy to talk about the hearsay issue. As we set forth in our briefs, what we alleged in the trial court below is that the FBI engaged in coercive police activity by the way we characterized it, really trying to hijack the enormous of the authority of the defendant's employer and indeed the CEO to engage in a form of.
And so your argument is that the coerciveness of the interview was as a result of the CEO of the company being present for the interview. Is that correct?
That's part of it. And also the means by which it was set up. The CEO contacted, well, it wasn't clear if it was the CEO, but someone from the company contacted Mr. Russell and instructed him to be there at a particular time. So the authority of the employer was made use of to get him to come to the interview. But then also the CEO being there was obviously quite critical.
And you're claiming all this violated the due process clause of the Fifth Amendment.
Yes, Your Honor.
That was the involuntary interview with the FBI.
Absolutely, Your Honor.
Did law enforcement ask the CEO to be there?
They claimed that they didn't, but we don't.
Well, is there somewhere in the record that indicates that they did?
Not directly, Your Honor. I certainly attacked the credibility of that answer. The judge credited it, so that's a fact. But I would come at that this way. There's
When
two
you
aspects.
say the judge credited it, so that's a fact, you mean it's a fact that law enforcement did not ask the CEO to be present for the interview?
Correct, Your Honor.
Mm-hmm.
And he was convicted of accessing the medical records of a justice on the Supreme Court of the United States.
That's correct, Your Honor. Justice Ginsburg.
That was the conviction, and that's what that interview was about.
Yes, correct, Your Honor.
And he said he denied it and said his cat must have walked across the keyboard.
That was one of many statements. He said that he could have been, he denied doing it. He denied being the one to
But
access
he
it.
blamed it on his cat.
We think,
Accessing the records of Justice Ginsburg was blamed on his cat.
and he said there might have been someone else using his login and he thought it could have been human error were the other two things that he said.
Mm-hmm.
Those go more to the merits than the suppression issue, but that is part of the record in this case. As to the significance of the CEO, even if we assume, as the court certainly will, that she requested to be there, her presence is nonetheless highly significant for two reasons.
Because
One,
Paul set in the interview. That's what you're point is.
I'm sorry, what was the
The
first?
boss, his boss set in with the FBI.
Exactly, Your Honor.
He said it was the CEO of the company.
Exactly, Your Honor. I think we all should put ourselves in the shoes of a 29-year-old who had a lot of life experience, but very modest academic credentials. That job was a step up from being a fireman, more money. Imagine yourself being that 29-year-old, walking into a room, you have no idea what's coming, and walking in and seeing the FBI, and you're the CEO of the company from whom there's no higher authority to appeal
Somebody
to.
had accessed Justice Ginsburg's medical records
Sure.
at the Washington Hospital Center.
Well, it's George
And
Washington
they were trying to
Hospital.
figure out whether it was this fella.
Correct, Your Honor.
And his computer had. But he said it was his cat.
Well, as I said before, we
was
said a
his-
lot of things.
That was his explanation.
Well, I think Your Honor's question is a good one because it gets to why this interview was so significant. As we all know, the FBI does not record interviews. They never have or very infrequently. And so they use the employer to make this interview happen. That may not have ever happened if they'd done it a different
There's no
way.
evidence they used the employer.
Well, I think there is, Your Honor, respectfully.
I think she set in, and you argue that was intimidating, but
Yes.
that's the issue made up after the fact.
Did the employer ask any questions or say anything during the interview?
There's no details on that in the record.
So no?
No, Your Honor.
I thought she did muse about how a computer could be used to this effect, and in fact, suggesting that there might not be anything to this. Do I have that wrong?
I'm sorry, didn't fully hear the question.
No, I thought that she sort of just made a statement about more out of curiosity, that she wasn't sure how anyone could do this kind of thing, given the facts that had been, that she understood them to be.
That might have been from the trial test of the CEO.
Oh,
Didn't
okay.
testify at trial. That might be where that came from.
Okay.
I'm not sure if that was during the interview.
All right. Well, let's talk then about the interview, because you raise not an illegitimate concern about having someone's employer in the room at the time that your client is being questioned, but at bottom, he wasn't required to be there, right? It was a voluntary interview. He could have walked away, didn't have to show up, right?
That's correct, Your Honor.
Okay. So there were no weapons displayed, right? Nothing in the record about that.
That's correct, Your
No
Honor.
handcuffs.
Certainly.
All right. Did anyone make a statement threatening your client with losing his job if he didn't comply?
Absolutely not, Your Honor.
Okay. The interview took place in a conference room and there was one door unlocked, as I understand it. Is that
Yes,
right?
Your Honor.
So what is it about this, other than the fact that his employer was there,
Mhm.
that makes this so coercive as to amount to a constitutional violation?
Because of the obvious implications to his livelihood that any reasonable person we submit in his circumstances would have immediately drawn.
But that would have been the case whether or not his boss would have been there or not. I mean, the allegation was that he used his job
Mhm.
and the computer access related to that job to access a sitting Supreme Court justice's medical file. Any reasonable person would have understood that this might cause some problems with my job.
Well, that's a separate inquiry, whether that's the facts of the substance of the offense is a separate, distinct inquiry towards the voluntariness of the interview.
Don't you agree that the totality of the circumstances is what we look at here?
Yes, Your Honor.
So how could everything that Chief Judge Diaz just laid out be a separate consideration when we look at the totality of the circumstances?
For two reasons, Your Honor. One is the analysis is different in a sort of a white collar case than it is in the case involving, street investigations where most of the case law comes from, about locked doors and handcuffs and stuff. And
You're saying this is sort of a white collar case?
it was a white collar setting of professional people, CEOs, organ transplant coordinators in an office. It wasn't some robbery suspect like in Giddens.
So
It's
less
all-
threatening or coercive of an environment.
Right. It's less about he was afraid, he thought he was arrested. This isn't like he thought he was in custody. The coercion was a much more subtle, and I don't walk away from that because the Supreme Court's cases explicitly warn about the subtle methods that the courts have to be aware of. And so the coercion here is not scaring him, it's not punching him in the face or something. It was in so many words, but without words, but very loudly communicating to him.
And I think I would understand that better if it wasn't for the voluntary nature of the interview. This wasn't an involuntary thing. He could have left.
Well, so could the defendant in Giddens, who the facts were pretty clear in that case, could have left, but there were implications that if he was going to leave, he wasn't going to get his car back, which is certainly a very important means of livelihood, as this court recognized to many people.
You said you had a second point, and the first one was the white collar-ish nature of the second.
Thank you.
What was your
Thank you for
second?
bringing me back to that. The real important point is not only that the judge got the totality of the circumstances wrong, but that the judge, we think, applied an incorrect rule of law that implied economic coercion had to be explicit, and that didn't come from nowhere.
Judge Nachmanoff understood that he needed to examine the totality of the circumstances, and he said so.
But that's part of the ruling,
And
but
he
there was.
analyzed the totality of the circumstances and ruled against you.
Well, I think he analyzed it with ruling out of court certain critical things. I think it's critical to understand Judge Nachmanoff's rulings, and this is in the appendix, to recall that the government took a very aggressive position that they're not taking before this court, that threats to economic coercion as a matter of law had to be explicit, which we admit was not the case here. It was implicit. We think that rule of law is wrong, but I think it's clear.
But you think that the district court decided this based on there not being an explicit threat, and you think that was wrong. But I'm
Exactly.
looking at what the judge said on JA 81 and 82, and the district court said there are no cases that find that the mere presence of the employer or the CEO could be construed as a threat, implicit or explicit.
I guess
So
that's right.
that indicates, to me at least, that the district court didn't just focus on there not being an explicit threat,
Well, that
because that's what the court said.
I take that two different ways, a couple different ways, Your Honor. First, I read that as the judge emphasizing that I didn't have a case, which I admit that I don't, saying that an implicit threat of economic coercion, whether from a CEO or somebody else, constituted a threat to voluntariness. But we also have to consider that passage alongside other comments from the judge, which are cited in the brief, some of them from the exact pages of the joint appendix Your Honor just cited, specifically finding there was no explicit threat to livelihood from the CEO, no explicit threat from the agents. He questioned me about that during oral argument. Over and over again, the judge referred to the lack of an explicit threat, which is exactly the position the government was urging upon him, both in the briefs and in their oral presentation. And that focus on the lack of an explicit threat bled over into the analysis of the totality of the circumstances, where Judge Nachmanoff even said, accordingly, after having found there was no explicit threat, he says, accordingly, I find that there was no, overbearing of the will. So the ultimate finding was explicitly, in the judge's own words, tied to the mistaken position urged by the government that, as a matter of law, implicit threats to livelihood can't count. That's why we think that's so significant. I see I've got only 1 minute left. I'm very sorry I didn't get to talk about the HIPAA issue. Maybe I could just quickly summarize the argument on that if there's no further questions on suppression. Just very quickly, Your Honors, I think the key thing I want to emphasize in my last 30 seconds with the HIPAA conviction is obviously that's a matter that no court, either this court or anywhere else, has really considered in this context. The definition of individually identifiable health information, I would summarize it as really having two parts. The information has to reasonably identify, one, the person involved to a reasonable degree of specificity, and two, and this is what's critical for this appeal, is either the medical condition or the particular treatment, one or the other, or possibly in different facts, something about how
How
the
is that
person.
consistent with the text of the statute, which simply requires the information to relate to the past, present, or future physical or mental health of the individual? That seems to be a much broader description than what you want us to adopt here.
Well, it all depends on the construction the courts want to put on relate to. There has to be some limiting principle there. Otherwise, it's going to apply to, the tickets at the parking garage, at the hospital.
That's not
and-
this case.
It isn't, but in terms of being interpreted the statute that's consistent with congressional intent, I think if you look at all the district court cases that both parties have cited, the overall thrust of the cases is that this statute needs to be cabined in at least a little bit. And so the interpretation I'm proposing, I would submit, is consistent with the language of the statute that refers to medical conditions at treatment The interpretation I'm urging upon the court is that there has to be at least a reasonable degree of certainty or at least some kind of reasonable inference as to either the condition or the treatment. Doesn't have to be both. It can be one or the other. And for the reasons explained in the brief, we don't have either one of those here.
Did he conclude that she was being treated for cancer?
He, meaning the judge?
No, he meaning your client.
Well, of course, our position was always that he didn't do any of it.
I thought he'd sent some messages or something to that effect.
Well, he was acquitted of that part of it, Your Honor.
Well, that's another thing,
Mhm.
the evidence. Yeah.
No, Your Honor, there is
You're
no
talking
evidence.
about the third count. You're taking it to the third count.
He was acquitted of that conduct.
Well, I know you're saying he was acquitted,
Mhm.
but,
And-
but that evidence could carry over to the first two counts too.
It potentially could, but I don't think it resolves the narrow issue here. And I think that it's critical to separate in the analysis what the whole world knows about the late justice's struggle with cancer. She was very public about that. Everybody knows it. We have to separate that from the specific information that was alleged to be accessed here, which tells us next to nothing about the medicals.
Didn't the specific information indicate that there were medical services that included oncology?
The oncology, but it said the word oncology as in the context, it was an administrative section of the hospital that would have covered risk assessment consultations, it would have covered
Or
group.
what, but what does oncology mean?
Oncology has to do with the study and treatment of cancer, but
It's not a leap then to say that that's what the justice was there for.
it is though, Your Honor. It's
Something related to, going back to the language of the statute, cancer.
I wouldn't agree that that inference lies because as a matter of common understanding, oncologists do risk assessments for people that maybe have been in a coal mine, let's say, or they have family history. They go to an oncologist to say, what are my chances? They do rule out work. Someone's having a symptom, they have headaches, and they go to an oncologist to see if it's cancer. There's all sorts of people who go to an oncologist to get certain kinds of treatment,
All related to cancer.
but it doesn't mean the person has cancer, and that's what the statute
Right.
gets at, is medical condition or treatment. I see my time is, thank you for the extra
Right.
time. I appreciate it, Your Honor. Thank you.
Thank you.
Good morning, and may it please the court, Lauren Beebe for the United States. Unless the court has a different preference this morning, I'll go ahead and start with the suppression issue. And I just want to say at the outset that the court is absolutely right. This is a totality of the circumstances inquiry. We have to accept Judge Nachmanoff's factual findings as true unless they're clearly erroneous. And this is exactly the correct totality of the circumstances inquiry that Judge Nachmanoff conducted in denying Mr. Russell's motion to suppress. He made a number of factual findings, including explicitly finding that the agents did not ask the CEO to be there, that the CEO chose to be there. That's at the bottom of
But even
JA.
accepting all that, the fact is the CEO was there in the room when appellant was being questioned about a potential crime he had committed while at work on his office computer. That sounds like a pretty coercive, that would make me sweat type of environment, right? So what's the government's response to that not being unduly, at least implicitly coercive? And I think opposing counsel used the phrase economic coercion.
Sure, absolutely. And we do agree that this implicit economic coercion could be a threat or a sufficient condition of coercion in certain cases. We do not think that's this case. There are many cases holding that kind of an intimidating environment
So
is
what
not
would need,
enough.
what kind of cases? What else would have needed to happen here besides the fact that the CEO of the whole company is sitting there breathing down your neck while the law enforcement is asking you questions about a crime you committed at work?
Sure. So
Allegedly.
points, or actually probably 3 points. So first of all, I will say just as a factual point, Russell actually committed the crime from his home desktop using his login credentials and everything. So that at the work is a little bit potentially ambiguous. I will also
Where did he
say
work? From home?
He worked at home and also he went.
So
into
he
the
was at work.
hospital.
When he, so we don't have to debate about that.
Okay, yeah, sure. I do also want to say, I know there were a couple questions about what Miss Brigham might have said during the interview, and this is in the record. It's mentioned, and it says that the only thing that Miss Brigham said during the interview was she wondered aloud what sensitive information could be derived from simply searching for somebody's
What's
name.
the JA site for that?
So it's referenced at JA 16, and that's part of the motion to suppress brief. It was attached as an
So
exhibit
that goes back
to
to
that.
probably what Chief Judge Diaz was asking about.
Exactly. And so the only evidence we have that Miss Brigham said anything during the interview was, if anything, friendly to Mr. Russell. And she was kind of opining aloud, against that these would be potential HIPAA violations. And she was friendly in that regard. But then the key point, I'd say, Judge Thacker, is that the problem is, even if the CEO's presence was somehow coercive, there's no evidence whatsoever that there was any coercive police activity. Even if the CEO was coercive police activity is what's a necessary predicate to finding of involuntariness. And that's what makes this case categorically different than Garrity and the other cases that my colleague attempts to rely upon. All of those cases involved, for example, policemen who were told by their superiors that they would be fired if they didn't cooperate, or public school teachers, things like that.
Let me
Public
ask you this. What if
officers.
the FBI had expressly invited this defendant's employer to that interview, and then the employer is sitting there and says something along the lines of, gee, it's a really nice job you have there, Mr. Defendant. It'd be a shame if you lost it by not speaking to these friendly agents. Do you have anything you want to say? Are you suggesting that even though the agents never said anything to him, that wouldn't satisfy, that wouldn't be a coercive environment?
So I think that would be a much closer and a much different case.
But
And
you seem to be saying that so long as the agents don't say anything, they're in the clear.
no, I think if the agents were kind of taking advantage and had orchestrated the allegedly coercive environment, so in the hypothetical you were giving where they asked the CEO to be there and kind of capitalized on that, that would be a very different case. Here, there's just no evidence that the agents asked her to be there, even that they wanted her to be there. In the declaration from Special Agent Ford, he actually says they wouldn't have wanted her to be there. They would have rather done it themselves. And that's just
They could have said, sorry, you can't be there.
exactly, but they didn't. And perhaps that was because they thought that maybe she wanted to be there in support to Mr. Russell, in support of her employee.
Really?
She, from the get-go and throughout this case, even after the trial and everything, she did not fire Mr. Russell. She was very supportive at trial. She testified that she really wanted to believe that he was innocent until proven guilty. She didn't think he was a bad guy. Overall, I think both at the motion to suppress hearing and then at trial, there's nothing to suggest that Ms. Brigham was this kind of intimidating, coercive figure. And as to your hypo too, I know that was discussed actually with Judge Nachmanoff, and he said that would be basically an explicit threat. If even if just the employer had said, hey, what a nice job you've got there, would be a shame if you lose it after this interview, like, let's go into the conference room. That would be a very different situation.
So it depends on whether you have a mean boss or a nice boss? Isn't the imprimatur of being the CEO of the entire company sufficiently coercive enough, whether the boss is mean or not?
So I think, again, it depends on the coercive police activity and whether the agents were kind of facilitating and taking advantage of that. But that is part of the totality of the circumstances. And the thing is here that Judge Nachmanoff found that there was nothing either in their interaction between the agents and the defendant or the CEO that was either explicitly or implicitly threatening or coercive police activity. He made a factual finding that Mr. Russell was fully capable of making the decision to speak and answer the questions the way that he wished to do. In fact, he felt free to admit incriminating information that violated his company's rules in front of his CEO. You'd think if he was scared that Ms. Brigham was going to fire him, he wouldn't have admitted to these violations, to password sharing, to things like that. That would have been grounds to fire him. And even after those admissions, Ms. Brigham did not fire him. He remained employed. And just overall viewing the facts in the light most favorable to the government here, we have to defer to Judge Nachmanoff's factual findings. They're not clearly erroneous. And he held that based on the totality of the circumstances, there was no basis to conclude that Mr. Russell's will was overborne.
I'm going to change gears here a minute. This prosecution was in Virginia. the medical records were in Washington DC. We have rules that require counsel to tell us in briefs something about jurisdiction. And that wasn't done here, for some reason. But you prosecute this fellow in Virginia, for committing crimes, on the face of it, records were in Washington DC. Now, the appellant says, we have appellate jurisdiction under 1291 from a final order, which is the law. But how the case get to Virginia, he doesn't explain.
Yep.
And you all don't say anything about it.
An
You
apology.
don't mention jurisdiction at all. And the rule says that if you don't mention jurisdiction at all, you adopt his position.
And we agree.
It doesn't say anything about the jurisdiction of the prosecution.
Sure.
The jurisdiction of the appeal is all he's covering. So I'm just wondering why you all abandoned your obligation to tell us what the jurisdiction was in the District of Eastern Virginia.
Sure. And I apologize for that oversight. I don't think there was any dispute about jurisdiction, so that's
Well,
probably why we didn't do it.
we
but
have
just
we have
to
to
be-
have jurisdiction in order to.
Exactly. And so the records were accessed remotely. The records were accessed from, I believe, the GW hospital kind of mainframe that was based in DC.
But
they
you
were
don't explain
accessed
that.
from
And
Mr.
you don't
Russell.
explain that is your jurisdictional hook.
We
That
don't.
he
in
was
our-
in
in
Virginia
our
when
appellate
he
brief.
accessed, when his cat got on the computer. That was in Virginia.
And the
But you don't
destruction
explain
of,
that.
the
That's all I'm
destruction
getting at.
of records, also the obstruction was in Virginia. And I believe
we
that's
have
the
an
joint
obligation.
appendix in the
The court
indictment.
always has an obligation. We do. We're the court of limited jurisdiction. We have to figure out jurisdiction when the lawyers don't help us. And so there's a specific provision in the rules about briefs that say you all are supposed to help us.
And I do apologize that I believe it's in the joint appendix. I could find you the precise number for the indictment.
I mean, you gotta really find brief on everything except jurisdiction, as I see it. But anyway, I just wanted to point that out. But this happened in Virginia. The accessing is what you're saying.
The accessing and
How about
also
the interview? Is it in
destruction.
Virginia?
The interview was at Falls Church, Virginia at the
Okay, interview been in
WRTC.
Washington DC, you've been in trouble here, maybe today.
I think still because the destruction of property that formed the basis of count one occurred in Virginia undisputably, we'd still have a basis there, but I agree it might be a closer question. If we can, I'd like to move on a little bit to the HIPAA issue. And I just want to, I think Chief Judge Diaz is absolutely right that the statutory language here is broad. This court in United States versus Spence, the Supreme Court in Morales v. Trans World Airlines has repeatedly said that related to is very broad language. Nothing in the statute kind of requires this particular treatment or particular condition language that my colleague is trying to read into the statute. And to be clear, the information here included not only Justice Ginsburg's name, gender, birth date, age, the facility, GW Hospital, where she was inpatient, but also information for 10 different patient events from 2013 to 2018, each with an identified event type, medical service, and arrival and discharge dates. In addition to the reference to oncology, there were several references to radiology. There was reference to an ambulatory surgery surgical event. Another one of the entries showed an overnight inpatient medical event. And just under any plausible interpretation, there was sufficient evidence for the jury to conclude that that information related to either the provision of healthcare to Justice Ginsburg or to her past or then present physical health or condition. And that's all the statute requires. I also want to point out, I believe, Judge King, you asked a question whether Mr. Russell himself had acknowledged that based on the screenshot, you could tell that Justice Ginsburg had cancer. I don't believe that Mr. Russell acknowledged that, but I did want to make the point that my colleague acknowledged just that during the cross-examination of one of the witnesses at trial. He said, and I quote, this is from JA 273 to 274, so it would appear that just based on that screenshot alone, the justice had been receiving treatment from GW for various things related to cancer seemingly since at least 2014. Is that right? And then they showed.
You're saying that's what counsel said, but what counsel said is not evidence.
Well, so
So
then the
what was the
witness
answer?
responded, yes, that's
But he said
accurate.
yes.
Yeah.
He adopted exactly what the lawyer said.
Exactly. And then there was another
He
question.
adopted cancer.
And in closing argument, again, he said, you saw the records, she had cancer, period. It was very clear, I think, from, Judge Nachmanoff, from counsel's back and forth with the witnesses and throughout trial, that there was no dispute that these medical events in history did reveal more, I think, than what's required under statute, something relating to provision of healthcare, but clearly about, the provision of healthcare related to and again, I don't think this is necessary, but a specific particular health treatment that she was receiving treatment for at GW facility.
I heard Mr. Burnham say that the fact that Justice Ginsburg was suffering from cancer was not, it was publicly known, so that by itself might not be enough. Do you agree that if all that the records say or said was that she was being treated for cancer, would that be a different case, or would that still be a violation of the statute?
I think that would still be a violation of the statute. Nothing in the statute or what he was charged with turns on what was in the public realm. And especially if you're thinking about, particularly sensitive information about Supreme Court justices. I know at one point the court did announce to the public that Justice Ginsburg had cancer. That does not minimize Mr. Russell's conduct in this case or somehow make it accessible or acceptable to then go ahead and try to access the justice's information, private protected records for yourself. It might explain why Mr. Russell was interested in searching for this, but it certainly is not a defense, and there's no kind of public information or any defense to the access provision here in HIPAA. I do think it might be a different case if it just said, one thing suggesting she had cancer. The Hartley case in Northern District of Illinois, I think they would definitely say that's still sufficient. I think where the line falls between, plausible reading of the text isn't something that this court has weighed in on. I don't think this is a particularly borderline case, so I don't think we have to really discuss the outer bounds. I think this falls squarely within what the statute contemplates. If I can, I know my colleague didn't mention anything on the cross-examination issue. I did want to point out, I believe Judge King made a comment at the outset that there was bad hearsay evidence introduced. That is not what the issue is about. The issue is a cross-examination ruling where Judge Nachmanoff prohibited one line of testimony that would have elicited Mr. Russell's own prior out-of-court statements. As
The district court didn't entirely prohibit that, correct?
Exactly. So he prohibited the one line of questioning, maybe the specific question that my colleague had proposed to ask, but he expressly allowed him to question about bias, about during the course of the investigation. And I think this all occurs at JA 382 to 386. It's really clear that Judge Nachmanoff did not prohibit any line of inquiry. He invited the defense to continue their questioning at that time or to recall the witness later in the defense's case in chief. And that's our main point. We don't think there was any error, but for the same reasons, that shows harmlessness. And that's just like the cases in Zayad, Smith, Gin Wright, where it's repeatedly said that, especially when the defense is complaining of something that they could have solved by calling the witness and their chief, the defense's failure to do so rests on his shoulders, and that does not show any error by the district court. Unless there are any questions on that cross-examination issue or any others, thank you. We'd
Thank you.
ask that you affirm.
Thank you, Ms. Beebe. Mr. Burnham?
Your Honor. A couple of points from my colleague's argument. There's a lot of emphasis on the factual findings that the judge made, and I want to make it clear that we contend that those factual findings actually support us. A lot of the case law, as I alluded to earlier, comes from more rough interrogation techniques, where in this method, the whole point was that the interrogation was supposed to be very civilized, very friendly, very genteel. That's what made it effective. So of course they weren't going to lock the door or say anything intimidating. That wasn't the strategy. We have to remember police are very skilled at going right up to the lines that this court and others draws of what they can do, and they know how to take every advantage they can. And God bless them for that. We wouldn't have it any other way. And the bottom line here is here's an innovative, subtly coercive technique that very powerful, and we think the court should be alert to it. Secondly, in terms of the police actions here, just to summarize, my two contentions are that the critical facts are that at the behest of the police, one, the request to Russell didn't come, I keep saying the police, the FBI, the request to Russell didn't come from them. It came from his employer. We don't know who, but it came from the employer. So the police, as I keep saying, used the employer to help make the interview happen. Secondly, in response to some of the discussion on, did the CEO ask to be there? Was she nice? Was she mean? This court, I think, can rely on its many collective years of experience to find that the FBI doesn't have a practice of inviting random people in to interviews. They want to keep those environments very controlled so they come out the way the FBI wants. That the CEO was allowed to be there represents a deliberate investigative decision by the FBI. They didn't have to make. They could have said no.
Do
They
you want us
almost,
to take judicial notice that the fact that you just recited?
yes, Your Honor. I think the courts can.
We'd be taking judicial notice of something that the district court didn't know. Didn't
Oh,
take.
I would submit the district court probably knows it better than any of
Well,
us.
he
Judge
might know
Nachman.
it. Whatever he could know it, but you didn't ask him to take judicial notice.
There could easily be, I wouldn't be surprised if there were hundreds of decisions from this court that would justify the finding that the FBI normally conducts interviews without third parties being invited to be present. I could submit a 28J letter with,
They normally do a good job.
oh, sure,
We all recognize that probably.
certainly, Your Honor. In terms of the argument about the, was it a concession that I asked that cross-examination question? First of all, there's no cases cited in the government's brief because there aren't any. The cross-examination question is a concession. But even if there were, as I
I
alluded,
guess it's the answer that was the concession,
well, the answer
the
was,
question.
that's right, but the question specifically refers to the justice. And as I said before, the whole trial took place in the context of her condition, her cancer being publicly known. There was a Supreme Court police officer who testified. And so when I referred to the justice, that referred to Justice Ginsburg. And then I would submit, you can look at the record and say, oh, well, we know she had cancer, and look at this record. Well, GW was probably treating her for that. That's totally separate inquiry from what is or is not individually identifiable health information. Your Honor, Justice Diaz asked an interesting question, is if it just said she had cancer, well, I wouldn't even concede that that would count, because all cancer means is that, if you look up the medical definition, is that some part of one's body has cells in it that are growing too fast, and there's a big difference between, different kinds of cancer. But that isn't even the appropriate hypothetical, because as I tried to argue in my colloquy with Judge Thacker, is we contend that the materials at issue here don't even support an inference that the subject had any form of cancer, because we don't know if the treatment was for cancer or for, as I said, risk assessments, rule out work, or other types of medical services. Finally, as to the,
Can you, before you move to something else, can you tell us what rule you would have us apply in this case that would delineate the parameters of what the statute requires in order to convict?
sure, Your Honor, that the materials have to have enough to either directly inform the reader or support a reasonable inference as to either the condition or the particular type of treatment. So maybe they reveal that someone's having a hysterectomy, or maybe they reveal some condition for which a hysterectomy might be one type of treatment. They have to have one or the other. That's the interpretation that I fully concede that this court would be the first court to say that, but I think we can draw some support. I'm sorry, was Your Honor about
No,
to? We can draw some support from the available district court opinions that a narrowing construction for this statute is appropriate. This is a very broad statute. It doesn't require the government to prove any kind of bad motive. It just requires unauthorized access. It doesn't have to require the government to prove that the person knew what they were doing was illegal. It could just be a misunderstanding. This is like one of the statutes that Justice Gorsuch writes in his book about federal laws that apply to everything. And I think we see that a little bit in the available district court opinions, trying to cabin in this statute a little bit. For example, there are decisions that hold that a person that goes to, let's say, the University of West Virginia hospital website and clicks on 100 different articles on, kidney failure, and that gets disclosed. That's, on the face of it, would seem to be information that relates to an IP address that's very interested in kidney failure at the University of West Virginia. But the courts have held that that doesn't count. That type of information doesn't count, even though on the face of it, it seems like it could. And so I go into that
Information has no connection to a particular patient.
if the IP address is shared, I would submit that it does, because the IP address goes in many cases to a particular person.
Whose IP address are you talking about?
These comes from almost all of the available court opinions deal with these website cases. And so the argument the plaintiffs or civil cases make is that my IP address being John Smith and my activity on these hospital websites, including extremely detailed information
You're
is,
talking about the IP address of the person who's doing the searching.
yes, Your Honor.
So that doesn't, to go to Chief Judge Diaz's point, that doesn't go to personally identifiable information about a patient. You're going back to the offender.
No. This, in the cases I'm talking about, it is the patient whose IP address is being shared. And sometimes it's in the context of clicking on things like make an appointment. So it's clear that it is the patient, it's clear who the person is, and it's pretty clear.
Wait, how is the patient's IP address being shared?
In these cases, it's automatically through technology that I couldn't.
No, but I thought it, okay. Go
I
ahead.
couldn't begin to describe it.
So it's the patient who's doing the searching.
Correct, Your Honor.
Okay.
And in
now-
pretty much all of the available district court cases.
Okay, so
that,
I understand now. It's the patient that's doing the searching in what you're talking about, not
I'm sorry.
an offender doing the searching.
Exactly. I'm sorry if
Okay.
that was confusing. And I know that's a distinct factual pattern, but I went into the detail that I did to make the point that I think there is an effort underway in the district courts to cabin in the statute a little bit, to give it a more relatively narrow construction than the government is arguing for, much more along the lines of what I'm suggesting, because the statute is so broad. Thank you, Your Honors.
Thank you.
Mhm.
All right, we're going to come down and greet counsel, take a short recess before moving on to our third and final case.
Recess.
Seated. Our third and final case, 25-1469, Geneva Enterprises LLC versus Chavez. Mr. Tucci.
Morning, Honors. May it please the court, Robert Tucci on behalf of the defendants appellants in this matter. The Federal Arbitration Act has been on the books for over 100 years. The Supreme Court has interpreted that act to apply a federal policy favoring arbitration. And in the employment context, that has meant over the past couple of decades that arbitration agreements that are required as a term of employment be enforceable. And additionally, that several other restrictions on the ability of employees to gather together in class or collective arbitrations have been restricted as well. That is a posture that we find ourselves in this matter. My clients pressed forward what's called a mass arbitration before the American Arbitration Association, the AAA. And what a mass arbitration is, it's a amalgamation of multiple individual arbitrations. Typically, these cases would be brought in a class setting. However, because of the Supreme Court's recent decisions in Stolt-Nielsen and Lamps Plus, that has required these arbitral forums to adopt policies favoring mass arbitrations to process them in an efficient manner. The plaintiffs in this
So
case.
basically, you want to go to arbitration and you're saying that the other side's refusing to do so.
That's correct, Your Honor. And specifically, the employer in this matter, Geneva, has refused to pay their initiation fees to even get the arbitration
The court
started.
already ordered arbitration, did it?
Your Honor, that's in dispute. Certainly, we do not, my clients do not believe that the district court ordered or compelled arbitration. What occurred in the district court was that the employers, Geneva, filed a motion for preliminary injunction to prohibit the mass arbitration from proceeding. That motion was denied. My clients simultaneously filed a motion to compel arbitration and to stay the district court action pending the completion of the claims in arbitration. The district court did not grant our motion to compel arbitration, but
Did
did
the district court specifically deny your motion to compel?
Well, Your Honor, it's not clear from the June 2024 order what the disposition was of the motion to compel arbitration, but at the hearing on the same on June 6, 2024, the district court did indicate that he would be denying the motion. He did also, of course, deny my client's motions for sanctions and indicated that the case would be stayed pending resolution of the claims in arbitration. So at that point, my clients went back to the AAA. They
What did the order say that's on appeal here?
So once my clients went back to arbitration after the June 2024 order was issued by Judge Hilton, we presented the order to the AAA, and after that, Geneva still refused to pay their portion of the initiation.
What does the order say that's on appeal here?
And so the order in the March 2025 order, after our renewed motion to compel arbitration was filed, states that it appeared to the court that the matter was already referred to arbitration and the case stayed, and that my clients provided no essentially good reason to lift.
So the district court didn't compel arbitration, it just acknowledged that arbitration was ongoing. Is that a way that you would put it?
I think so, Your Honor, and more so, just to kind of put another step there, I think what the district court did was refuse to prohibit the arbitration from proceeding. So he denied the motion for preliminary injunction, but he did not compel arbitration to proceed. And
He said arbitration is ongoing. You just said. The order says arbitration is ongoing.
My apologies, Your Honor. The order does not say that the arbitration was
Does it say?
ongoing. It's the June 2024 order.
No, the order that's you tried to appeal here.
The March 2025 order, the one that's on appeal right now, states that it appeared to the court that the matter was already referred to arbitration.
It appears to the court that the matter was referred to arbitration.
That's correct, Your Honor.
And is that an appealable order? The one you've got up here now? is there any jurisdiction in this court to review this thing?
And to kind of sort through the Gordian knot of jurisdictional issues, certainly under Section 16 of the FAA, we believe that the jurisdiction does lie under 16A because the court denied our renewed motion to compel arbitration. Now, through our supplemental briefing that was ordered last week, this court's decision in Pisgah really looked at two angles to the jurisdictional analysis, 16A, 16B. 16A, and the way that the court, discussed that issue was orders favoring arbitration are generally not appealable. Orders not favoring arbitration generally are appealable. Of course, you have to dig into the details there, and this is such a case. There was also a tangential issue in terms of whether a order granting a motion to compel arbitration could be immediately appealable if the action was what's called an embedded action or a standalone action. We didn't really address that in the briefing, but that's an interesting issue here because the posture that we find ourselves in, Judge King, is that Geneva
None of that
filed.
was addressed by Judge Hilton.
That was not addressed by Judge Hilton, Your Honor. And it actually was not raised by Geneva either. Geneva raised no jurisdictional arguments in the district court. Now, whether this is an embedded action or a standalone action, I think is an alternative route to get to the subject matter jurisdiction for the district court here. Geneva filed this as an injunctive action under Section 4 of the FAA. If it's a standalone action, you're looking at whether the motion to compel arbitration was the sole thing that the district court was to act on.
You're back to talking about jurisdiction in the district court.
That's correct, Your Honor. Yeah.
Okay. I'm talking about jurisdiction in the Fourth Circuit.
My apologies, Your Honor.
Jurisdiction.
There's a Gordian knot of jurisdictional issues.
Jurisdiction from the 2025 order. The
Right.
one- That's the one that you're appealing.
Right.
And we have
Appellate.
to have jurisdiction of that one before you can do anything.
My apologies, I misspoke. This would relate to appellate jurisdiction. So whether the case is an embedded case or a standalone case under Section 16 to essentially provide a right to appeal, that is, look through the prism of what was the district court doing in the action? Was there other claims that were at issue? Was there another trial as there was in Pisgah, for example? There was a breach of contract
He
trial.
said, I'm keeping the stay in place. And it appears that arbitration is ongoing. Correct? In that order.
In the March 2025
The
order.
one, that's the one that you're trying to appeal now.
That's correct, Your Honor.
But you're trying to appeal is ruling that the stays in place, stay of this proceedings in the district court, right? And that arbitration is ongoing. It appears that arbitration is ongoing. That's the whole thing that the court ruled. Courts don't, there's a general rule, courts speak through their orders. We agree with that, right?
That's correct, Your Honor.
That's the order. And so you have to be able to have appellate jurisdiction of those things to be here. Otherwise, we don't have any jurisdiction. We're a court of limited jurisdiction too.
And that's kind of my point regarding Pisgah, Your Honor, is there certainly is appellate jurisdiction under two routes. First is Section 16A. The motion to compel arbitration was denied. The arbitration was not on.
That doesn't say anything about the motion to compel arbitration being denied. It says appears that arbitration is ongoing. You read it to me.
Your Honor,
It appears arbitration is ongoing and the stay is left in place. And there would be no stay unless arbitration was ongoing.
my apologies.
The stay, imposing the stay is part and parcel of getting arbitration.
Doesn't it say at the end at JA 1411, the renewed motion to compel arbitration is denied?
That's correct, Your Honor. And to your point, Judge King, the order does not say that the arbitration is ongoing. It states that
It appears,
it appeared to the court that the matter was referred to arbitration.
all right. It
Um,
appears that it was referred to arbitration,
that's correct. Your Honor.
okay? And the stay is left in place.
And the stay was left in place. That's correct.
And the
So
stay would not be left in place unless it was there was arbitration. That was, they're part and parcel, right?
Well, and
You
that's,
have a stay because you got arbitration.
well, certainly under section 3, the stay was entered pursuant to section 3. Now, section 4, that's what our application was under. We wanted an order compelling arbitration, or at the very least directing the parties to arbitrate their claims consistent with the arbitration agreement.
So assuming we do have appellate jurisdiction, what is it you want us to do?
So, Your Honor, first, we would like the court to reverse the district court's order denying our motion, or our renewed motion to compel arbitration, and direct the district court to enter an order compelling arbitration consistent with the terms of the
No,
arbitration
But
agreement.
how can the court compel, as I understand it, what the other side is doing is just not paying the arbitration fee. So naturally, the arbiters don't want to work for free. So how can we or the district court compel the other side to pay the fee?
Well, that's straight out of the text of section 4 of the FAA, Your Honor. It states that the court can compel arbitration consistent with the terms of the arbitration agreement. The arbitration
Are
agreement,
there any courts that have adopted your proposal that we can compel a party to pay arbitration fees?
well, Your Honor, this is a bit of a unique situation,
Can
certainly.
you say yes or no?
That's a no.
That's a no. We were not
Yes.
able to locate a case.
So would be pounding a new furrow, so to speak.
That's correct, Your
If we
Honor.
agreed with you on that.
That's correct, Your Honor. And certainly mass arbitrations are a new furrow as well. And so I think
Well, the
we're,
problem here, though, is that you want to arbitrate, and you want to arbitrate pursuant to the AAA's arbitration rules. And that comes with both benefits and problems for you, because the rules contemplate that in a situation where the one party refuses to pay the arbitrator's fees, that's a decision for the arbitrators to decide. In this case, they provided a number of options. They said, you pay the fee if you want to move forward. You don't like that, obviously, but that's not an issue, it seems to me, for the district court to be involved in just yet, because the arbitrators have control over this precise issue.
Your Honor, the issue is not whether the arbitrator should resolve the fee dispute. The issue is, how do we get to an arbitrator? How do we actually
Following up on what Chief Judge Diaz said, the arbitrator told you how. You confront the fee since the opposing side won't pay it.
Well, Your Honor, there was no arbitrator appointed in this matter.
Why didn't
But
you front the
somebody-
fees? I thought that's exactly what happened. They said you could put the fees up, and if you prevail, you get your fees back.
My clients did pay their fees.
Whether their
Pay their
fees.
fees.
Front the money.
Well, and that was certainly an
And
option.
you go ahead and arbitrate.
That was an option
And
presented.
that's what probably what Judge Hilton was talking about when he said it appears it's an arbitration.
And that was an option presented to my clients, Your Honor. However, the AAA acknowledged in their declination letter that that Geneva violated the terms of the AAA rules.
Right,
That's
but if
incorporated.
that was an option presented to appellant, why doesn't that foreclose your argument that we should just make the other side pay in order to go forward with arbitration? You have the ability to go forward with arbitration.
Your Honor, because the declination letter issued by the AAA states that the case was administratively closed due to Geneva's non-payment. It stated, of course, that they would be willing to reopen the matter
Okay?
upon payment of Geneva of its initiation fees, and then move on to the arbitrator selection process.
What about upon payment by your client fronting the fees?
Your Honor, that's certainly an option, but that would be outside of the scope of what Geneva was required in this situation. And that would certainly be an unfair result for my clients who are employees. They did not draft this arbitration agreement. They were not the ones that chose the
But that's an
AAA.
issue for the arbitrator, not for the district court, once the district court sends us to arbitration.
That's correct, Your Honor. And Geneva can absolutely raise that dispute before an arbitrator once one's appointed, but we're not able to get to that step yet because they have not satisfied.
But you are, because you could front the fee. How much are the fees?
Roughly 7,500, Your Honor.
Okay, so appellant could front the $7,500 and get to arbitration, right?
Well, sure, of course, but
A lot more cost effectively than going through an entire appeal to the Fourth Circuit, it seems like.
well, Your Honor, that's That would be Geneva's responsibility under the rules, right?
No, I understand that, and and then if you could get the money back later in, assuming later in arbitration.
But the issue is what would happen after that point? If Geneva still contests the arbitration, they would not pay the arbitrator compensation, they wouldn't pay the
I
administrative
guess we would
fees.
cross that bridge when we came to it, but we're not there.
Well, I suppose the response would always be, my clients could forward Geneva's share of their costs and arbitrator expenses, but that is simply not what the agreement contemplates. And I see I'm out of time, Your Honor, so if you, any further questions.
You want to finish your thought about the answer to Judge Thacker's question?
Well, and that's simply it, Your Honor. It's the rules adopt the fee schedule, and the fee schedule shifts certain responsibility on different parties. Here, Geneva had a responsibility to pay its portion of the initiation fees. My clients already paid their portion of the initiation fees. To require my clients to front and the full burden of the arbitration, that is outside the scope of what the agreement requires. We're simply trying to get the agreement enforced according to its
Back
terms.
To the district court and have the district court do it. The district court enter the stay.
Right now, Your Honor, what we're asking for is an order, simply an order compelling arbitration or referring the dispute, directing the parties to arbitrate their claims consistent with the terms of the arbitration agreement. What happens after that point, I think that's a bridge we can cross when we get there. But right now, we don't have an order that says that. That's all we're trying to get.
All right, thank you. Mr. Machado.
Good morning, and may it please the court. My name is Les Machado, and I represent the appellees in this matter, what we're collectively referring to as Geneva. There are three independent reasons why the court cannot grant the former employees the relief they seek, which is an order requiring Geneva to pay the disputed fees. First, when the former employees removed this case from the Virginia Circuit Court to the Eastern District of Virginia, there was no subject matter jurisdiction. As such, the proper remedy is to remand the case to the district court with instructions to remand it to the circuit court.
What's the basis for the lack of subject matter jurisdiction?
So, Your Honor, we'll take a step back. The former employees filed 31 demands for arbitration. Geneva's belief was that the former employees had not complied with certain conditions precedent in order to proceed in arbitration. So Geneva filed a complaint in state court that was effectively seeking to stop the arbitration because they hadn't complied with the conditions precedent. That was the purpose of the complaint. That was the complaint that the former employees removed to federal court, but there's no federal court jurisdiction on the face of that complaint. There's nothing in there that would give the federal court federal question jurisdiction.
And you're talking about a different jurisdiction issue than I talked about with him.
Correct.
I was talking about appellate jurisdiction. You're saying even if there is appellate jurisdiction, there's no district court jurisdiction.
And I'll be honest, I'm not sure which comes first, subject matter.
Well, I
appellate.
think we have to have jurisdiction first
Well, let me then
before
address,
we can get to your question of district court jurisdiction.
then let me address the appellate jurisdiction argument first, Your Honor. The March 27 order under appeal here is not an appealable order.
So you say there's no appellate jurisdiction.
That's correct. As the former employees concede, what we're looking at is a system that says if the order being challenged on appeal is pro-arbitration, it's not an appealable order. If it's antithetical to arbitration, it's an appealable order. The order under appeal, the March 27th order, was a pro-arbitration order.
But the face of the motion was a motion to compel arbitration, and Judge Thacker just read the portion of the district court's ruling that effectively denied that motion.
I think you have to look behind the title of the motion and the one sentence in the order to see what they were actually looking for. What the former employees wanted was an order requiring Geneva to pay the arbitration fees. So it was a renewed motion to compel arbitration and require Geneva to pay the arbitration fees. And we may get to that question about, is that something a federal court can even order? And the answer to that is no, as 5 other circuits have held. But that's what I think Judge Hilton was denying. He was saying that I already ordered this case to arbitration. I already stayed the case. I'm maintaining the stay and effectively sending you back to the arbitration that I already ordered last year. He's by no means saying that this case is going to proceed in federal court. That's the kind of order that would be appealable is a case that's antithetical to arbitration, that says, no, these claims are not subject to arbitration. We're going to proceed in the federal district court with these claims. Those are the types of claims that Section 16 says, those are the types of orders that Section 16 says are appealable. But that's not what this order did. Judge Hilton in no way, shape, or form thought this was a case or now Judge Trenga, is a case that he's going to litigate. He maintained the stay and sent it back to arbitration. And that line that Judge Thacker read, I think was really about what they really want, what they're actually looking for, what this whole appeal is about.
You say it's about what they want. I say it's about what the court did. I mean, any lawyer, at least when I was a lawyer, when you get a court order, I don't care about all this stuff up here. I flip right to the end. And what's the bottom line? What did the court do? And the bottom line here is the court denied the motion to compel arbitration.
It certainly has that language in there, Your Honor, but I don't think you can divorce that sentence from the remaining portion of the order, and I don't think you can divorce it from what transpired previously.
The remaining portion of the order it simply appears to me to acknowledge that arbitration, it's already been referred to arbitration.
That's exactly right, Judge Thacker. So if you take a step back to the original order that the court issued the prior year, that was after, again, our client had filed essentially a motion to stay the arbitration, to stop the arbitration, to enjoin the arbitration because of the former employee's failure to comply with these conditions precedent. The former employees filed a motion to compel arbitration, and what Judge Hilton held at that time after the oral argument was, I'm not going to stay the arbitrations. Go forth and arbitrate, and that's contained in his order from That's contained from his order from 2024, which is at JA 1392. This action is stayed pending resolution of the parties' claims and arbitration. That's what he's referring to in the March 2025 order. I've already stayed this case. I've already directed the parties to
Do
arbitration.
you now think that we don't have appellate jurisdiction? So where would that leave us? Where would that not leave us? Nowhere. Where would it leave you all?
I think it sends it back to the district court. That's my view to
do what?
Start figuring out what happens next.
You raised this issue of a lack of subject matter jurisdiction over the initial action, which I hadn't focused on before. Did Judge Hilton rule on that?
It was not raised at the time of the removal, Your Honor.
Okay.
But of course, subject matter jurisdiction can be raised at any time, and this court has an independent obligation to assess whether there was subject matter jurisdiction, even if it was raised for the first time on appeal. So let me get now to that aspect, which is even if there was appellate jurisdiction, we don't think there was subject matter jurisdiction in the first place. Again, when the case was removed.
Which one did we look at first?
I'm not sure.
We're the appellate court.
Yeah, I don't know I don't know the answer to that.
You don't know the answer?
I don't think.
Well, you're our lawyer. You're supposed to be telling us.
I think either way,
We're the appellate court. Do we have appellate jurisdiction?
No.
Did the district court have jurisdiction over the case?
No.
So you say there's no jurisdiction any way you look at it?
Correct.
Okay. And if there is jurisdiction, what's the answer?
If there's both subject matter jurisdiction in the first place, which we don't think there is, and I'm happy to talk through why we think that's the case. And if there's appellate jurisdiction over the March 2025 order, although again, that order was not antithetical to arbitration, it was a pro-arbitration order. Then we get to the merits, and the merits are.
I'm sorry to derail you, but Judge King raises an interesting point with respect to the issue of what do we decide and in what order? If we were to decide that there was no appellate jurisdiction, I don't think we can say anything more, can we?
I think that's probably the case, Your Honor, and then it goes back to the district court.
Why would that probably be the case? Why wouldn't that absolutely be the case?
I'm still struggling.
We can't go giving advisory opinions.
I'm still struggling.
We have to have jurisdiction.
I'm still struggling.
If we don't have jurisdiction, there's a thing called dismissal.
And that's lawyers, they go to the very
then we
bottom.
call the next case. We should have had another case here. If we were going to dismiss this, we could have called another case.
I'm going back
We
to,
can't deal with this.
I know there's a fair amount of first years in the room. I'm going back to first year Civ Pro and I'm
If we
struggling
go
with.
back, you say Judge Stringer's case now.
Yeah, I'm
He
struggling
probably
with
doesn't
whether
want to be-
subject matter jurisdiction is essential before you get to appellate jurisdiction, or if appellate jurisdiction comes first before you can revisit subject matter jurisdiction. But to your question, Judge Diaz, if the court concludes there is no appellate jurisdiction, then I think that ends this appeal. It goes back to the district court, and presumably the parties can litigate there about whether the district court.
So you've got a position now. Your position, primary position is there's no appellate jurisdiction, and that means a dismissal.
Correct,
End of case.
correct. If this court,
But
So they would, what is it the parties would litigate in the district court when the district court, the last word the district court said is, this is all in arbitration?
well, if
And
we,
you won't pay the arbitration, or not you personally, your clients won't pay the arbitration fees. So they're just in purgatory over here.
not at all, Your Honor. Let me address that first. So if this court found there's no appellate jurisdiction and went back to the district court, presumably the parties could then litigate in the district court about whether there's subject matter jurisdiction. So that would be an issue for the district court to then resolve. Assuming the district court found subject matter jurisdiction get to the merits of this case, which is, does a federal court have the authority to order parties to pay the fees in arbitration? The answer to that question is no. As the Second Circuit is held, as the Fifth Circuit is held, as the Seventh Circuit is held, as the Ninth Circuit is held.
And I will say, I was very surprised when I read those cases. It seems that you're right, but it would seem to sort of blow a hole in a district court's order compelling arbitration if one side can just dig in its heels and say, I don't care what the district court said, I'm not paying.
And I understand the intuitive appeal of that, Your Honor. I think the challenge that the former employees have is that the statute works in a certain way. It provides a very limited and narrow role for the federal district court in the first instance. Under Section 4, you file a motion to compel arbitration if one of the sides is refusing to go to arbitration. The district court's role at that point is very circumscribed. Is there an enforceable arbitration agreement? Are the claims within the scope of that agreement? If the answer to those questions is yes, the district court's role ends until a final award is issued, and then it may be reviewed under FAA Section 9 or FAA Section 10.
But if one party refuses to go to arbitration, refuses to pay the fees, there will not be a final award, will there?
But time and time again, the problem is those issues about disputes over fees are issues for the arbitrable body, not for the district court. And so when it goes to the arbitration and the arbitrable body has to resolve those issues, those are procedural issues for the arbitrable body. And here, that's what happened. It went to the arbitrable body. They had multiple opportunities. And I know you've talked at some length about the invitation for them to pay the fees, but even beyond that, the AAA rules say you can ask us to waive the fees or delay the fees. You can appoint a.
Oh, that perhaps answers the question I was thinking about, is whether, if appellants were indigent and could not afford to pay the fee, they could seek a waiver, is what
The
you're saying.
AAA rules, and we cited them in the brief, certainly give the AAA a lot of discretion when it comes to fees. And it gives the parties, and here the AAA exercised that discretion, and it said, Geneva pay the fees. And when Geneva didn't pay the fees, it said to the former employees, would you like to pay the fees? And if they had paid the fees, we wouldn't be standing here today, but they declined to pay the fees. That's their decision.
So if they had paid the fees and your client still said, I'm not going to arbitration, then what?
I think it would depend on what the arbitrable body did, Your Honor, because again, what we can't have is district courts or federal appellate courts getting into the minutia of arbitrations. You could take almost anything that happens in an arbitration and come back to court and say they are refusing to arbitrate. Think of the example that the Second Circuit did in the Twitter case. They said, think of a discovery issue where the arbitrator says to one party, I'm ordering you to produce these documents. The party doesn't produce the documents. We can't have the other party running to court and saying they're refusing to participate in arbitration. They're neglecting the arbitration. Compel them to participate in the arbitration. Those are issues. Once the district court's role ends and it goes to the arbitration, everything that happens thereafter, fees, discovery, length of hearings, whether it's going to be in person, whether it's going to be video, all those things are for the arbitrable body to decide and not for the courts to micromanage or second guess. To Judge Thacker's question, though, and perhaps to what you're thinking about, Judge Diaz, it does not leave the former employees without a remedy. They could have, again, sought all of those relief from the AAA. They could have paid the fees, or they could have come back to the federal district court and said, Geneva has waived its right to participate in the arbitration. It is not, the arbitration, which was Geneva's idea, can no longer go forward, and we should be allowed to proceed in federal court, which is what all these courts say, the Second Circuit, the Fifth Circuit, the Seventh Circuit, and the Ninth Circuit. The former employees are not without relief, but what they want is what this court can't order.
So you're saying that the trial court could reassume jurisdiction and go to trial?
Or again, this is an odd case because there's actually not a complaint pending. The former employees never filed their complaint in the district court. The complaint or the case that was filed in the district court was essentially our motion to stay the arbitration. But yes, the former employees, I think, and again, that's what all these courts say, is it doesn't leave the person without relief if, for whatever reason, and sometimes it might be indigency, and that's certainly the case in some of these cases why the fees weren't paid. In other of these cases, there's no question it wasn't indigency. There's no question that Samsung had the ability to pay the fees in the Seventh Circuit and didn't pay it. There's no question that Twitter had the ability to pay the fees in the Second Circuit case and didn't pay it. And the courts nevertheless said, okay, but whatever the arbitrable body decided when it had this dispute, and what it decided apparently in those cases is the same thing it decided here, which is a failure to pay the fees by either party, because both were given those opportunities. We're going to close these proceedings, doesn't leave the former employees without remedy. They can go to the court. They can say, the arbitrable body is now close to us, and we want to proceed in the appropriate court, state court or federal court, and the case would proceed. We would have no argument at that point to say, no, 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 these claims belong in arbitration. We wouldn't be making that argument because we would have essentially waived those arguments about the arbitration. So
Can I ask a question about mass arbitration and the process by which it works? I don't know that it informs this case, but I was just curious. I think you said this, somebody said this in the case, that part of the concern with mass arbitrations is the exorbitant fees that an employer might have to pay. $7,500 doesn't seem like all that exorbitant to me, but is that wrong?
I think when you look at the cases across the landscape, Your Honor, what you find is cases where that certainly is a much more meaningful number that the employer is required to pay.
Is it per case or just one?
I believe it's per case, and I believe, and I'm doing this from memory, I believe the Samsung case, which was in the Seventh Circuit, I believe it was $17 million is what Samsung was required to pay.
I'm in the wrong line of work.
Yes. So I think, and again, whatever the reason for why the fees weren't paid, frankly, doesn't matter at the end of the day. What matters is, can a federal court order the fees to be paid? And the answer to that is no. And in the absence of those fees being paid, in a case where the
fees here were about $7,500.
Correct.
And you're representing car dealers.
Correct.
These were employees of the car dealers who want to, who are on the other side.
Correct.
Former employees.
31 former employees.
31 former
largely
employees.
bringing.
And 27 of them have arbitration agreements. And you say 7 of them or 4 of them don't even have haven't signed the agreements or something.
Correct.
But those aren't for us.
That's Judge Hilton held.
Those questions aren't for us.
Judge Hilton held that those threshold issues were for the arbitral body to decide about whether.
And that sounds like Judge Hilton was right on the money. If those other 5 circuits are right that you said you had on your side.
And again, every circuit to have considered this issue has held unequivocally that federal courts don't have the ability to second guess what an arbitrable body does when it comes to a fee dispute, just like it doesn't have the ability to second guess what an arbitrable body does when it comes to any other procedural dispute or ruling.
The arbitrable body that you're calling is an arbitrator.
Or in this case, a case administrator, because the arbitrator hadn't yet been appointed.
Okay, and hadn't been appointed yet.
Yes.
But it would be, once it's appointed, that's the arbitrator.
Correct.
Your colleague on the other side actually makes that distinction. He says there is no arbitrator. The arbitrator hasn't decided anything.
And that's no different than any of the other cases, Your Honor. If you read the Wallet case in the Seventh Circuit, it also stopped at the case administration stage. No arbitrator had been appointed. Again, there was relief available to the former employees at that stage pursuant to the AAA rules. They could have asked for a variety of different things to try to get the case moving, notwithstanding the payment of fees, or they could have simply paid the fees. Or they could have gone back to Judge Hilton and said, they've waived their right to proceed in arbitration. We want to now proceed in this court or the circuit court or whatever the appropriate court would be. Those were all remedies that were available to them. But the one remedy they want is one that this court or no federal court can order, which is an order that Geneva pay the fees, because that, again, is an issue for the arbitrable body to have decided and not for the courts to second guess. And so we briefed the subject matter jurisdiction argument in our brief. I'm not sure it makes sense for me to walk through that. In short order, the motion that we filed in the state court that was removed to the federal court did not on its face provide for federal court jurisdiction. The former employees say, well, a week after removal, we, the former employees, filed a motion to compel arbitration under Section 4. And when you file a motion to compel arbitration under Section 4, you can look through to the underlying complaint. And if that underlying complaint raises federal claims, then there's federal jurisdiction. But federal court jurisdiction's fixed at the time of removal. And at the time of removal, there was no federal court jurisdiction on the face of the complaint. You can't say a week later, I'm filing a motion that will provide federal court the ability to look through and look to the underlying complaints. And even if you could, even if that late filed week later Section 4 motion could be used to ground federal court jurisdiction, when you look to those underlying complaints, there are 31 separate complaints. One had a federal claim. The other 30 had purely state
And
law
what was the
claims.
federal claim?
It was an FLSA claim under the Fair Labor Standards Act. The other 30 complaints had claims for breach of contract under the Virginia wage payment statute. And the former employee's argument is, well, you can use supplemental jurisdiction to bring those 30 complaints, state law complaints, attach them to the one complaint with a federal law claim, and voila, we have federal court jurisdiction. But that's not what the law says. It wasn't a class action. They weren't joined. There weren't intervention. It was 31 separate complaints, and only one of which had a federal claim in it. So even if you could rely upon their late filed 1 week after removal Section 4 motion as a basis for federal court jurisdiction, and you look through that Section 4 motion, you could not use that to find federal court jurisdiction over all 31 complaints. Of course, if this court finds that there's no appellate jurisdiction, then that is an argument we would raise with the district court on remand. So for any one of 3 reasons, we would request, first, if the court finds there's no appellate jurisdiction, that the court dismiss the appeal. If the court finds there is appellate jurisdiction, that the court find that there was no subject matter jurisdiction in the first place and remand the case with instructions to remand it to the circuit court. And third, if the court gets to the merits of the appeal, that the court join every other appellate court to have reached this issue and conclude that it lacks the authority to grant the former employees the relief they seek. Thank you.
Thank you very much, Mr. Machado.
Your Honor, just a few points on rebuttal here. With regards to the jurisdictional argument, I agree. I think the appellate jurisdiction issue has to be addressed first, but of course, we believe there is appellate jurisdiction whenever that in my opening argument. And then, of course, for the subject matter jurisdiction, the Supreme Court's decision in Vaden provides a look through, as my colleague just on the other side just mentioned, there is an FLSA claim in the underlying dispute. Geneva filed this action under Section 4 of the FAA. Same section that provides for a petition to compel arbitration. They cited the FLSA claim in their papers. That provides a subject matter jurisdiction for the district court. Now, with regards to the merits, the issue of who should pay the fees is really separate from what do we do from this posture. The motion to compel arbitration was never granted. That is what my clients want. We want an order compelling arbitration or directing the parties to arbitrate consistent with the terms of the arbitration agreement. That incorporates the AAA rules. Now, there was no arbitrator appointed, so the arbitrator never made a decision of who should pay what fees. Geneva can present that issue to the arbitrator at that point. The arbitral body, the case administrator that made the determination of that Geneva did violate the rules, said so in the declination letter. And
Can you explain how the 4 or 5 cases that your colleague on the other side, they all seem to go against you, and you need to explain why that shouldn't be the result here.
Yes, Your Honor, we laid that out pretty well in our reply brief, but Walrick and Hoag, which were both Seventh Circuit decisions, and then Frazier, which is a Second Circuit decision, those cases aren't controlling here, and they're actually materially different. They involve.
Not controlling because they're out of circuit.
That's correct, Your Honor. They involve either, number one, an administrator who terminated and steered the parties to court, as was the case in Walrick. B, lacked proof of a present refusal to arbitrate. Or C, that there was a live arbitration where the court was asked to micromanage a fee allocation midstream where the arbitrator made a decision regarding the fees. So here, we haven't even gotten to step one. We haven't even gotten an arbitrator appointed. The AAA, as is distinguished from Walrick, did not say, okay, now you can go to court. They said, if Geneva will pay the fees, we will administer the case. But because they haven't done so, we're not only refusing to administer the case, we're also directing Geneva to remove our name from their arbitration agreements. That way, there's no confusion to the public, and they can't invoke our services in later cases. So right now, my clients are in a bit of a catch-22. What do we do from here?
Pay the
Right.
fee.
Advance the fees, front the fees.
That would go outside the four corners of the arbitration agreement. Simply, we're simply asking the court to
And then
enforce.
something, though, that you would then argue in arbitration?
Correct, Your Honor. Yeah, if Geneva wants to raise that argument that my clients are the ones responsible for the fees, including the initiation fees and any other fees.
No, what you just said is something you'd argue in arbitration. You front the fees as it's been suggested that you do. And then if you think that having to pay that is outside the scope of the arbitration agreement, then you argue that to the arbitrator and you get it back as part of your award.
But that's not my client's burden, Your Honor. That's Geneva's burden to raise that dispute before the arbitrator. They're the ones saying we should not have to pay these fees. Fair enough. Pay the fees, bring it to the arbitrator. We'll make the determination from there. The AAA said the same thing. We're not administering the case because you violated the rules. You didn't pay the initiation fees. Just because my clients could forward an advance on the fees doesn't mean that Geneva breached the arbitration agreement by refusing to follow the AAA fee schedule, as the case administrator noted. With regards to the and actually, that's a good point, Your Honor. Think about the
You agree
converse.
this case is in the district court's been stayed?
I'm upset. My apologies, Your Honor.
Your case in the district court has been stayed.
That's correct.
Right? And
But it's not.
and the only reason in the world it was stayed is for arbitration.
Well, Your Honor, it's a bit of a complicated dynamic.
Is there any other reason on the record for the stay except that arbitration?
It's an injunctive action. So the case was
Is there any other
stayed.
reason on the record for the fact that it's been stayed?
No, Your
It
Honor.
was stayed for arbitration. And it appears, whatever the district court said in that order, that arbitration is ongoing.
I don't believe the court said arbitration is ongoing, and I see my time's run out. If I may
Nobody
just
said
have a brief
You can
moment.
answer.
I just want to draw the court's attention to the converse. Let's say my clients were to file arbitration demands in the AAA and refuse to pay their initiation fees, claim that it was Geneva's burden to do so. At that point, the AAA would do the same thing. They would refuse to administer the cases. My clients could then go to court and say, okay, well, the AAA, Geneva has refused to pay my clients' portions of the fees, so we should be able to proceed in court. I mean, it's an absurd result. The FAA, as the Supreme Court has said, clearly favors arbitration, and we're asking this court to reverse the district court and direct the district court to enter an order compelling arbitration, and the alternative, at least lift the stay so my clients can see their day in court. Thank you.
All right, thank you, Mr. Tucci. I want to thank both lawyers for their arguments here this morning. We appreciate them. I must say that I was disappointed to hear that lawyers only care about the bottom line and don't read our opinions, but I guess you shouldn't be surprised. Hopefully you read this one when it comes out. We'll come down and greet you. We'll take a short recess, come back and start the Q&A when we come back. Or adjourn court.
God save the United States of the